Thousands of people detained by ICE during its Operation Midway Bliss in Chicago are about to be set free. Why? Because the Trump administration violated a 2022 consent decree with the city that says that ICE cannot use the excuse that they believe someone's a flight risk as an excuse to lock people up and detain them indefinitely without getting a search warrant first. And that's what it looks like Greg Bovino and his thugs have been doing in Chicago. They boasted about having 3,000 people they say they arrested and detained. The judge identified 615 people that he said were probably eligible for this alternative program that says that you detention, there's an alternative program that they all qualify for, so they shouldn't be locked up. So he says those people need to be set free. The Trump administration said there's about 12 or so of that 615 that are actually criminal flight risk. And the judge said, that's fine, I'm not trying to get in your way, but you cannot be violating an active consent decree, which was probably part of a lawsuit, an investigation or something, whatever. It turns out the Trump administration lied. In advance of coming, they told the folks on the ground that consent decree had been dissolved. Not true. But that's what they do. They lied. And so, yeah, that's what you're looking at. Then sitting people going to be able to be set free. And that's what I tell you all the time in JJ Legal. I'm in the dockets. Take you from the headlines, beyond the headlines, to actually what happens. And I have been telling you, if you follow my account, that they violate the law, the First Amendment, the Fourth Amendment, the Fifth Amendment, 14th Amendment, the separation of powers, the 10th Amendment, separation between the states and federal government. They violate this thing called Administrative Procedure Act that says if you're going to change the law drastically, you need to give public notice and comment. You need to develop a thorough record based on stats, facts, statistics. If you want to revoke the temporary protective status of any group, for example, you need to give them 60 days notice. If you want to revoke grants, it has to be on an individual by individual basis. It can't be a bulk grant, just dropping them all based on cut and paste buzzwords in the grants or based on culture wars. It has to be on a specific reason and has to be tangentially related to the grant. You can't just remove grants because you don't like the fact that they support people of color. That's not a basis. It has to be, it violates the Administrative Procedure Act, and that's what they've been doing. Reduction in force without doing a proper notice, proper process, and that's what they do. And because they don't follow proper process, all the people that are negatively impacted by the Trump administration's actions promptly go and sue, and the courts can say, this is the process. Did you follow the process? And the answer usually is no. So the executive agency, they're still bound within the law. They're still bound within the limits and the rules regarding notice before you fire someone, before you revoke statuses, and they don't do that. And that's why they get pulled back. And it's not activist judges, it's people following the law. And this is judges that were appointed by Barack Obama, George W. Bush, Ronald Reagan, Donald Trump himself, and Joe Biden. JJ Legal, each one teach one. Share this video so more people know. I'm in the docket.